Good afternoon, everyone. I'm Muhammad Haider Abbas, and you're watching me at Rostrum Legal channel on YouTube. Rostrum Legal is bringing you CLAT PG 2022 capsule course with recorded video lectures, study materials, more than 25 mock tests, and one-on-one mentoring and doubt clearing sessions. And I am here to teach you legal current affairs. Well, we have been doing various topics. We have discussed various topics in this week, and we will continue to discuss many other topics to come in the upcoming days, in the next week also. You will get the updates very soon. And now I want to take up today's topic. Today's topic is Endless Ordeal and on extradition of Julian Assange. I'm zooming it to 150% for you to read it properly. Okay? I hope my audio and visuals are clear and it is easy for you to read the PDF doc, I guess. Okay, so it is the today's topic is Endless Ordeal on extradition of Julian Assange. You might have come across this name, very famous name, Julian Assange, because Julian Assange is an investigative journalist, or you can call him a journalist only, who who is associated with, who is linked with the WikiLeaks. The WikiLeaks, the very famous document which has revealed many confidential informations of United States relating to Iraq and Afghan war. So the United States is it's on its toes right now to get him extradited from London and punish him under the Espionage Act of 1917, which is the law which is still in which is still under enforcement in United States from the era of the First World War. So he's actually dealing with it, and he's also facing the music of extradition right now. Uh, so an extradition of Julian Assange. There's one question from Somesh: how many lectures will be conducted for legal awareness approximately? See, we cannot limit the numbers right now. We cannot limit the numbers of lectures on legal awareness. We can limit it under codified subjects. We can limit it under IPC. We can do it under Constitution of India, or under uh, under the contract act and various other codified laws, but we cannot do it under legal awareness because topics keep coming in, and it is my duty to consolidate them, and to consolidate them into a week and take these lectures. Okay, so Endless Ordeal on extradition of Julian Assange, we are discussing it here because United States, democracies like United States, have time and again committed many war crimes like genocide, like like war crimes, various other war crimes, crimes against humanity. And these crimes were calibrated attempts of their armies in various countries, especially Iraq and Afghanistan. So so all these crimes which are committed by the United States military during its operations in Iraq and Afghanistan were and they were extremely confidential, were revealed and leaked by Julian Assange, an investigative journalist who is right now facing, he was there in the Ecuador embassy. Ecuador gave him the asylum in its embassy in London. While then he was arrested by the London police, and he was there in the London prison for more than 50 weeks for violating his bail orders, for violating his bail conditions. And then right now, the London High Court has issued orders for him to be extradited to United States for being convicted under the Espionage Act of 1917. So, what is important for us to understand right now? This topic deals with the various nuggets of information under the international law, the developments, the recent developments in the international law. Anything might be very old, any point of information might be very old, but if it happens to appear in any current issue, it becomes important as a part of legal current affair. Exactly what has happened with the Espionage Act of 1917 and the extradition law in the international law. So, in the background of the extradition of Julian Assange, we shall also be discussing and learning about the extradition law, and also about the key points, the key features of the Espionage Act of 1917. Besides this, we shall also be discussing certain important case laws, and the names of the people who have so far been indicted under the Espionage Act of 1917 in the United States. Okay, now I'm start reading the article. Endless Ordeal on extradition of Julian Assange. Assange should not be tried for exposing abuse of power and must walk free. This is what the writer is saying, that Assange should not be tried for exposing abuse of power and must walk free. The ruling by the High Court. See, there are plenty of articles available on various websites, and different writers, they write different things. You know, they write different things, they express their opinion, and these opinions are extremely personal. Okay, but what is important for us is to bring out important nuggets of information and understand a particular point of view, because these writers are also not mediocre people. Okay, so their opinions also matter. So it is important for people like us to also understand about their point of view. Okay, so Assange should not be tried for exposing abuse of power and must walk free. The ruling by the High Court in London that WikiLeaks founder Julian Assange, currently in a British prison, can be extradited to the United States, where he is facing charges under the Espionage Act, is a blow to all those who believe in press freedom. Many of you who are attending my class, many of you must be the staunch believers in the press freedom. I guess most of you, and quite less number of you, or perhaps no one, would agree that media should be state regulated. Media should be state regulated. Press freedom means that the electronic media, the print media, the digital media should be left completely free from these state regulations and from any restrictions. We also do have certain reasonable restrictions contained under Article 19, Clause 2 of the Constitution of India, to be imposed upon the press freedom. And in the name of reasonability, since we do not have any parameters for reasonability, and it is the prerogative of the state to decide that a particular restriction is reasonable or not as per its own whims and caprices, it becomes pertinent for us to look again into the reasonability of these restrictions. So long as we talk about democracy, the first and foremost thing that comes to our mind is the freedom of the media, the freedom of speech. Okay, so any person who is a staunch believer in the freedom of speech, would get a blow after knowing that Julian Assange, who was currently in the British prison, can be extradited to the United States, where he is facing charges under the Espionage Act. Don't get confused at this point of lecture, because we shall be discussing the extradition law as well as the Espionage Act. Okay? those who believe in the press freedom. A lower court had earlier this year rejected the United States' request for extradition, citing his mental health. Okay, a lower court, because when the matter went to the lower court, it actually starts from the lower court, you all know. When the matter started from the lower court, uh, earlier this year, particular lower court rejected the United States request for extradition because Julian Assange was not mentally fine. His lawyers and doctors had argued that he might be driven to suicide by American jail conditions. Since American jail conditions are pathetic, and it is not easy to survive in those jail conditions, especially when the prisoner or the person is not mentally fine. So the doctors and the lawyers, they pleaded that he should not be extradited to the United States, and accepting that plea, the lower court of London, you know, rejected the United States plea for extradition. But the High Court, after receiving some assurances from the US authorities, when the matter went to the High Court, the United States authorities gave some assurances before the High Court of London that he will be kept under good conditions, and he would not be held in restrictive prison conditions based on his conduct. And keeping those assurances, the High Court decided to allow the extradition. The United States accuses him of conspiring to hack into defense databases to get sensitive, unclassified information. What the United States alleges Julian Assange for: the United States accuses him of conspiring to hack into defense databases to get sensitive, unclassified information. Do you think this is a joke? No, obviously not. Julian Assange, an investigative journalist, this would all left us intrigued, that how can just one person can hack or conspire to hack into the defense databases, the most protected confidential databases in the world. The United States accuses him of conspiring to hack those very confidential and most protected defense databases to get sensitive, unclassified information. Okay. So the charges are very serious. If there is any word to define the superlative degree of seriousness, you may buy that word right now for the seriousness of the charge. The leaks, the United States says, put lives at risk. If if convicted, Mr. Assange, 50, who is just 50 years old, could face up to 175 years in jail. This 175 years is a calculated total punishment of all his charges and the total punishments of all those charges together. Nobody is going to live for 175 years, obviously, unless if God allows. But this is just a calculated period. That means he's going to live at least for the rest of his life behind bars. So Mr. Assange, 50, could face up to 175 years in jail. His legal team will now appeal, and the legal process could drag on for years. But these cases have already put him in one or the other form of confinement for years. He took refuge in the Ecuadorian embassy in London in 2012 while facing a probe on accusations of sexual assault in Sweden, which were later dropped. Okay, so these cases have already put him in one or the other form of confinement for years, because he also took refuge in the Ecuadorian embassy, the embassy of Ecuador in London in 2012, while facing a probe on accusations of sexual assault in Sweden, which were later dropped. So he has been facing charges, and he has been facing these kinds of things since very long. In 2019, after his arrest from the embassy, he was jailed for 50 weeks in the United Kingdom for breaching his bail conditions. And he is now in London's Belmarsh prison. He's now in London's Belmarsh prison. Okay. Now, what is the document WikiLeaks? The documents WikiLeaks released on the Iraq and Afghan wars, which were published by almost all media houses, exposed official crimes and cover-ups. You must be knowing that United States attacked Iraq and also invaded Afghanistan. It actually took the responsibility of policing the entire country, entire state of Afghanistan against the presence of Taliban, to dispel the presence of Taliban in the country. This is what United States has been doing so far in Afghanistan. Also in Iraq, in order and in the name of restoring democracy in Iraq, United States, and also in the name of dispelling terrorism and countering terrorism in Iraq, it attacked Iraq, okay, during the presidency of George W. Bush, when Saddam Hussein was finally caught and he was hanged. Okay, he was hanged. He flew away. His family got killed, and so many things happened in the Iraq war. So all these war crimes, whatever had happened, whatever calibrated war crimes were committed by the United States, okay, in Iraq and Afghanistan, were released in the documents called WikiLeaks, and they were published by almost all media houses because it exposed official crimes and cover-ups. Any responsible democratic government should have taken action against those who committed those crimes. Okay, any responsible or democratic government should have taken action against those who committed those crimes. I mean, if you know and if you have read, I must tell you that what is war on terror. You may just visit the Google and Google search engine and type war on terror. You would come to know what is war on terror. The United States attempt to start and dispel or counter terrorism in states like Iraq and Afghanistan and various other Central Asian countries was started in the first decade of the 21st century, with the dawn of the 21st century. So the decade of 2000 to 2010, from 2000 to 2010, this whole decade is the decade on war on terror, because the United States has continued to fight terrorism, or fight, we cannot say fight terrorism. We can say it has it has deployed its army, it has agitated wars against the governments in Iraq and Afghanistan, and in the name of dispelling terrorism, it started policing these nations, especially the country of Afghanistan, because it had much deep rooted presence of a terrorist organization called Taliban, which were dealing very harshly with the civilians and residents of Afghanistan, especially women. Okay, so any responsible or democratic government should have taken action against those who committed those crimes. No United Nations sanction was sought by the United States to start this war on terror in the first decade of the 21st century. And also, it is not the responsibility of the United States alone to deal with such kinds of things and start policing the other nations, other sovereign nations. Okay, so in the name of dispelling and countering terrorism, many war crimes were committed by the United States Army. So any responsible or democratic government should have taken action against those who committed crime, but all in vain. Okay. The instead, the United States government went after the publisher. The United States government did not see who committed those crimes. It should have taken note and should have taken cognizance of all those crimes which were committed in the name of countering terrorism in Afghanistan and Iraq. But keeping it aside, the United States was worried about that who published these informations. So the Trump administration unsealed the indictment against Mr. Assange for violating the Espionage Act, a First World War era law. This Espionage Act hails from the year 1917. 1917 का लॉ है ये Espionage Act. So ये फर्स्ट वर्ल्ड वॉर एरा लॉ है, and he was accused under the Espionage Act 1917, a First World War era law, after his 2019 arrest. The United States government argued that he was not a journalist. This was their plea, that he was not a journalist. But beyond the definition of journalism, what the United States tried to do was to use a controversial law to punish someone who published unpleasant truths about powerful entities. Don't, the writer is trying to explain that you should not see what he did was wrong. Just change your point of view. What Julian Assange did was that he published some unpleasant truths about the powerful entities. That's it. And these unpleasant truths should have been brought before the world. There's no harm in it. And United States as a responsible democratic government should have taken cognizance of all those who committed these crimes. But not too much surprise, the United States kept all those people who committed these crimes at bay, and ignoring them altogether, it went after the publishers of these informations. So if he is extradited and convicted, it would set a bad precedent for press freedom and investigative journalism, raising questions about the protection the First Amendment offers to the press. You must know that press freedom was brought in the United States with a very widened and broad scope after the First Amendment to the Constitution was brought. So this popular, very popular First Amendment to the Constitution of United States is known for introducing the press freedom in the United States. Okay, there are no restrictions on the press in the United States, like the way we have under Article 19(2) of the Constitution of India. They do not have any reasonable restrictions except a very few. Okay, so this raises questions that if the United States, as a responsible democratic government, is hankering after and is badly, running after the publishers, the press free, and after the media houses for publishing these unpleasant truths about it, okay, then it raises serious questions about the implementation and the reality of the First Amendment, because the press has the freedom to publish these kinds of informations under the First Amendment. And if it has this freedom backed by law, then no government can be after these media houses. And these press freedoms cannot be compromised in any manner, in any situation, in any circumstance. It is ironic, however, that the administration of President Joe Biden, who convened a global summit for democracy last week and emphasized the role of free press, is following Mr. Trump's policies and pursuing Mr. Assange. If the United States and the UK, among the world's oldest democracies, are serious about their proclaimed commitment to press freedom, they should take steps to set Mr. Assange free. See how ironic is this? These presidents are convening what? Summit for democracy. And they're talking about the freedom of the press in the Summit for Democracy, like the way we usually do in India also. We talk about the press freedom, and at the same time, we do not allow certain films to be exhibited publicly because certain sentiments are hurt. Okay, only because certain sentiments are hurt. So, Global Summit for Democracy was convened recently by Joe Biden in United States, and he talked about the freedom of the press. But if they actually want people to believe their, staunch commitment for press freedom, they should also set Mr. Assange free. The ordeal the free world has put this man in for exposing abuses of power has taken away years from his life and affected his health. This should not go on forever. Now, what is the law of extradition? Let us discuss. You must have read this, you must have learned this in your undergraduate course. what is extradition, but still I'm going to discuss in the background of this definition what is the Espionage Act of 1917, and also the various a few famous cases and the names of the people who have been have been convicted under the Espionage Act, who have faced charges under the Espionage Act of 1917. Extradition in international law is the process by which one state, we are talking about the nation state, not a state within the country. We are talking about the nation state. The process by which one state, upon the request of another, this is the exactly the definition of Britannica. The Britannica Encyclopedia defines extradition this way. This is its definition. This is Britannica's definition. Extradition in international law, the process by which one state, upon the request of another, effects the return of a person for trial for a crime punishable by the laws of the requesting state and committed outside the state of refuge. Okay? Outside the state of refuge. एक्स्ट्रेडिशन इंटरनेशनल लॉ में किस प्रोसेस को कहते हैं? जब एक नेशन स्टेट किसी दूसरी नेशन स्टेट की रिक्वेस्ट के ऊपर किसी ऐसे व्यक्ति को अपने कंट्री में वापस बुलवाती है जिसके ऊपर किसी जुर्म करने के इल्जामात लगे हैं, जो कि एक मुल्जिम है. मुल्जिम इज अक्यूज्ड, मुजरिम इज कन्विक्टेड. ओके, जब जुर्म साबित हो जाए तो मुल्जिम मुजरिम बन जाता है. ठीक है. फॉर ट्रायल फॉर अ क्राइम पनिशेबल बाय द लॉज ऑफ द रिक्वेस्टिंग स्टेट एंड कमिटेड आउटसाइड द स्टेट ऑफ रेफ्यूज. आउटसाइड द स्टेट ऑफ रेफ्यूज, उसको बुला के वहां पर कन्विक्ट कर देते हैं. ये एक्स्ट्राडिशन प्रोसेस है, ये लॉ ऑफ एक्स्ट्राडिशन है. एक लाइन की डेफिनेशन है इसकी. आप आई होप इसमें आप में से किसी को भी कोई कंफ्यूजन नहीं होगा. एक्स्ट्राडिशन इन इंटरनेशनल लॉ is the process by which one state, upon the request of another, effects the return of a person for trial for a crime punishable by the laws of the requesting state and committed outside the state of refuge. Okay. Extraditable persons include those charged with a crime but not yet tried, those tried and convicted who have escaped custody, and those convicted in absentia. Okay. Extraditable persons include those charged with a crime but not yet tried. Extraditable persons include those charged with a crime but not yet tried. जिनके ऊपर चार्ज लगा हुआ है क्राइम का, लेकिन अभी उनका ट्रायल नहीं हुआ है. Those tried and convicted who have escaped custody, and those convicted in absentia. एक्स्ट्राडाइटेबल पर्संस कौन कौन है? जिनके ऊपर नंबर 1 क्राइम का चार्ज लगा हुआ है बट ट्रायल नहीं हुआ है, या जिनका ट्रायल हो चुका है, वो कन्विक्ट हो चुके हैं लेकिन कस्टडी से भाग निकले. थर्ड, जिनका कन्विक्शन हो चुका है बट एब्सेंशिया में हुआ है. ओके, बट एब्सेंशिया में हुआ है. 3 तरीके के लोग एक्स्ट्राडाइटेबल पर्संस कहलाते हैं. एक्स्ट्राडाइटेबल पर्संस कौन कौन से कहलाते हैं? पहला, जिसके ऊपर क्राइम का इल्जाम है बट उसका ट्रायल नहीं हुआ है. दूसरा, जिसका ट्रायल हो चुका है, कन्विक्शन भी हो चुका है लेकिन वो कस्टडी से भाग निकला. तीसरा, जो कन्विक्टेड है बट उसका कन्विक्शन एब्सेंशिया में हुआ है. ठीक है, तो ये 3 तरीके के लोग हैं जो एक्स्ट्राडाइटेबल पर्संस कहलाते हैं. द रिक्वेस्ट डिस्टिंग्विशेस extradition from other measures such as banishment, expulsion, and deportation, which also result in the forcible removal of undesirable persons. Extradition का difference, extradition जो है वो अलग चीज है, और बाकी जो चीजें हैं banishment, expulsion, deportation, ये सब अलग चीजें हैं. One should not confuse extradition with banishment, expulsion and deportation. ये सब अलग चीजें हैं. एक्सपेल कर देना किसी को, एक्सपल्जन हो जाना किसी का कंट्री से, दैट इज अ सॉर्ट ऑफ पनिशमेंट. एक्सपल्जन हो जाता है बट इसके बियॉन्ड कुछ नहीं होता. ठीक है, डिपोर्टेशन हो जाता है. सो वी आर नॉट डिस्कसिंग दीज थिंग्स राइट अवे राइट नाउ. वी आर डिस्कसिंग एक्सट्रेडिशन. सो वी शुड नॉट कंफ्यूज इट विद banishment, expulsion or deportation. Okay, extradition is simply that on a request of one nation state, the other nation state sends a person to the former state, and this person happens to be accused of committing a crime. Okay, and this nation states send this person to the former state for facing the charges and facing the trial. Okay, according to the principle of territoriality of criminal law, states do not employ their penal laws to acts committed outside their boundaries except in the protection of special national interests. In helping to suppress crime, however, states generally have been willing to cooperate in bringing fugitives to justice. Okay? According to the principle of territoriality of criminal law, states do not apply their penal laws to acts committed outside their boundaries except in the protection of special national interest. In helping to suppress crime, however, states generally have been willing to cooperate in bringing fugitives to justice. क्रिमिनल लॉ, इंडिया का क्रिमिनल लॉ कहां एप्लीकेबल होगा? इंडियन बाउंड्री के अंदर ही तो होगा. इफ यू हैव रेड and if you have learned section 3 and section 4 of the Indian Penal Code, है ना, section 3 और section 4 में territoriality and applicability of the penal code डिस्कस की गई है. उसमें सीधा सीधा यही तो लिखा हुआ है कि जो इंडियन बाउंड्री है, स्टेट ऑफ इंडिया है, बस उसी के अंदर ये एनफोर्सेबल है, इसके बियॉन्ड नहीं है. इसके बियॉन्ड कुछ सिचुएशन में होगा, अगर इंडियन शिप जिसके ऊपर इंडियन फ्लैग लगा हुआ है वहां पर क्राइम होता है, या कोई ऐसी लैंड जैसे इंडियन एम्बेसी के किसी दूसरी कंट्री में, वहां पर क्राइम होता है, या इंडियन जेट में कहीं क्राइम होता है, तो वो इंडियन टेरिटरी को डीम किया जाएगा कि एज इफ द क्राइम हैज बीन कमिटेड विद इन इंडिया. बट these penal laws are not applicable without India. They are applicable within India. Okay, so this is done by every state. Every nation state does not apply their, every nation state does not apply their penal laws to act, does not apply its penal law to acts committed outside its boundaries. Okay, except in the protection of special national interest. Okay, but how is it possible then कि अगर बाहर पेनल लॉ नहीं चल रहा है, लाइक फॉर एग्जाम्पल किसी कंट्री में इम्पर्सोनेशन जो है वो क्राइम नहीं है, झूठी आइडेंटिटी बनाना क्राइम नहीं है कहीं पर, है ना. अगर किसी कंट्री में इम्पर्सोनेशन करना क्राइम नहीं है, लेकिन इंडिया में है, और इंडिया से कोई इम्पर्सोनेशन करके बाहर चला जाता है उस कंट्री में जहां पर वो क्राइम नहीं है, इसका मतलब ये नहीं है कि वो बच गया. Then comes into picture the law of extradition. Then India would request that particular country to extradite the person and send him or her back to India for facing the trial. Extradition is regulated within countries by extradition acts and between countries by diplomatic treaties. Okay. विद इन कंट्रीज एक्स्ट्रेडिशन कैसे चलता है? विद इन कंट्रीज हमने एक्स्ट्रेडिशन एक्ट अपने एक्ट्स बना रखे हैं. लाइक फॉर एग्जांपल मैं आपको एक्सप्लेन करूं, फ्यूजिटिव इकोनॉमिक ऑफेंडर्स एक्ट 2019 में आया है, आप लोगों ने देखा होगा, और मैं किसी दिन उस टॉपिक को लूंगा एज अ लेक्चर. ओके, क्या है वो फ्यूजिटिव इकोनॉमिक ऑफेंडर्स एक्ट? 100 करोड़ से ऊपर का घोटाला करके कोई भागा है यहां से, तो उसको हम एक्स्ट्राडाइट करवाएंगे, और फिर फ्यूजिटिव FEO एक्ट के अंदर उसका कन्विक्शन होगा, उसका ट्रायल चलेगा और कन्विक्शन होगा. तो ये फ्यूजिटिव इकोनॉमिक ऑफेंडर्स एक्ट क्या है? ये काइंड ऑफ एन एक्स्ट्रेडिशन लॉ है. तो कंट्रीज के अंदर इस टाइप के एक्ट्स और लॉज बहुत सारे बने हुए हैं, एक्स्ट्रेडिशन एक्ट्स बने हुए हैं, लेकिन कंट्रीज के बीच में एक्स्ट्रेडिशन कैसे एनफोर्स होगा? by diplomatic treaties. Okay, the first act providing for extradition was adopted in 1833 by Belgium, which also passed the first law on the right to asylum. देखिए ये नॉलेज का क्वेश्चन है, ये नगेट ऑफ इंफॉर्मेशन है, बहुत इंपॉर्टेंट, बहुत अच्छी बात, अच्छा पॉइंट है ये याद करने के लिए. द फर्स्ट एक्ट प्रोवाइडिंग फॉर एक्स्ट्राडिशन वाज अडॉप्टेड इन 1833 by Belgium, which also passed the first law on the right to asylum. So Belgium is the first country which legislated an extradition law in 1833, and also its first law on the right to asylum. Extradition acts specify the crimes that are extraditable. Okay, extradition acts specify the crimes that are extraditable, clarify extradition procedures and safeguards. अगर इंडिया रिक्वेस्ट करेगा तो क्या क्या प्रोसीजर्स होने चाहिए, क्या क्या सेफगार्ड्स होने चाहिए. इट स्टैपुलेट्स द रिलेशनशिप बिटवीन द एक्ट एंड द इंटरनेशनल ट्रीटीज. जिस कंट्री के साथ ट्रीटी हुई है उसमें सारी डिटेल्स लिखी जाती हैं. ठीक है, अगर इंडिया और यूनाइटेड स्टेट्स के बीच में या इंडिया या इक्वाडोर के बीच में कोई एक्स्ट्राडिशन ट्रीटी हो रही है तो इंडिया अपने एक्स्ट्राडिशन लॉज का पूरा पूरा जिक्र करेगा कि दीज आर द क्राइम्स अंडर विच एक्स्ट्राडिशन इज पॉसिबल. एंड हमारी आपसे ट्रीटी हो रही है, इक्वाडोर अपने एक्स्ट्राडिशन एक्ट्स बताएगा कि ये हमारी यहाँ क्राइम्स है जिसमें हम एक्स्ट्राडिशन करेंगे. फिर दोनों के बीच में ट्रीटी होती है. फिर इन केस कोई केस आ गया तो फिर ये देखा जाता है कि क्या वो एक्ट, इंटरनेशनल ट्रीटी जो हुई है इंडिया और इक्वाडोर के बीच में, क्या वो एक्ट एक्स्ट्राडाइटेबल लॉ है या नहीं है. ठीक है, तो स्टैपुलेट द रिलेशनशिप बिटवीन द एक्ट एंड इंटरनेशनल ट्रीटीज. ये सबका जिक्र इंटरनेशनल ट्रीटीज में होता है बाकायदा, और फिर एक्स्ट्राडिशन प्रोसेस को इंप्लीमेंट किया जाता है. National laws differ greatly regarding the relationship between extradition acts and treaties. In the United States, extradition may be granted only pursuant to a treaty and only if Congress has not legislated to the contrary, a situation that also exists in Britain, Belgium, and the Netherlands. Okay? In the United States, extradition may be granted only pursuant to a treaty and only if Congress has not legislated to the contrary. ठीक है, यूनाइटेड स्टेट्स में क्या है कि अगर ट्रीटी हो गई बस तो दैट इज एनफ. It is not necessary to have any extradition act in the country. Okay. The same situation exists in Britain, Belgium, and Netherlands. Okay. Germany and Switzerland extradite without a formal convention in cases where their governments and the requesting state have exchanged declarations of reciprocity. जर्मनी और स्विट्जरलैंड में क्या है कि हम आप जो है वो फॉर्मल एक्स्ट्रेडिशन नहीं करेंगे, कोई फॉर्मल एक्स्ट्रेडिशन नहीं करेंगे इन केसेस where their governments and the requesting states have exchanged declarations of reciprocity. Okay, दोनों के बीच में एक डिक्लेरेशन साइन हो गया रेसिप्रोसिटी का. ठीक है, आप हमारे साथ कोऑपरेट करिए, हम आपके साथ कोऑपरेट करेंगे इन दीज इश्यूज. तो जर्मनी और स्विट्जरलैंड कहते हैं हमारे आपके बीच में ये रेसिप्रोसिटी का जो डिक्लेरेशन है दैट इज एनफ, इसी में एक्स्ट्रेडिशन कवर हो जाएगा, अलग से कोई एक्स्ट्रेडिशन ट्रीटी की करने की जरूरत हमें नहीं है. तो ये कंट्रीज का अपना कॉल है, दैट इज देयर ओन कॉल एंड प्रेरोगेटिव टू डिसाइड if they want to enter into a specific and formal extradition treaty with each other, or if they simply want to enter into declarations of reciprocity, or if they want to legislate some extradition acts, or if they want to regulate the extradition process simply through an extradition treaty without having any extradition acts in their nations, like the way United States, Britain, Belgium, Netherlands does. Okay, so you know, this is completely the call and prerogative of these nation states. Although there has been a long standing trend towards denying extradition request in the absence of a binding international obligations. Okay, बहुत बार अब आजकल ऐसा हो चुका है, ट्रेंड बन गया है कि एक्स्ट्राडिशन रिक्वेस्ट को मना कर देते हैं, डिनाई कर देते हैं। अगर आपके और हमारे बीच में, यानी कि दो कंट्रीज के बीच में अगर इंटरनेशनल ट्रीटी नहीं है, इंटरनेशनल ऑब्लिगेशन नहीं है, तो एक्स्ट्राडिशन रिक्वेस्ट को मना कर देते हैं। बहुत सारे कंट्रीज ने किया है। Fugitives are sometimes surrendered by states on the basis of municipal law or as an act of goodwill. Nevertheless, countries that do not have extradition agreements with certain other countries or in regard to certain types of offense have been considered safe havens for fugitives. जिन जिन कंट्रीज में एक्स्ट्राडिशन एग्रीमेंट्स नहीं हुए, बहुत सारे कंट्रीज हैं, especially with regard to certain types of offenses, वो कंट्रीज फ्यूजिटिव्स के लिए, मुजरिमों के लिए, क्रिमिनल्स के लिए, ऑफेंडर्स के लिए पनाह बन चुके हैं, सेफ हैवेंस बन चुके हैं, have been considered safe havens for fugitives. Okay. Some principles of extradition are common to many countries. For example, many states decline any obligation to surrender their own nationals. Indeed, the constitutions of Slovenia and until 1997, Colombia prohibited the extradition of their nationals. बहुत सारे कंट्रीज अपने कंट्री के लोगों को एक्स्ट्राडाइट नहीं करते, लाइक स्लोवेनिया, कोलंबिया ने 1997 तक कोलंबिया भी यही करता था। अर्जेंटीना, ब्रिटेन एंड यूनाइटेड स्टेट्स nationals may be extradited only if the governing extradition treaty authorizes it. Okay, ये शर्त है अर्जेंटीना, ब्रिटेन और यूनाइटेड स्टेट्स में कि वहां के नेशनल्स तभी एक्स्ट्राडाइट किए जा सकते हैं अगर वहां की ट्रीटी ऑथराइज कर रही है। Another common principle is double criminality, which stipulates that the alleged crime for which extradition is being sought must be criminal in both the demanding and the requesting countries. Double criminality situation क्या होती है? What is double criminality? Double criminality is simply that if the alleged crime happens to be the crime in both the countries, the demanding as well as the requested countries. Okay, if for example rape or murder, this is a common thing, right? Murder is obviously punishable in all the countries. No country in the world would allow murder, right? So if this is known as double criminality, if a person commits a murder in India and flees to some other country which also has classified murder as a crime, punishable crime, then this would be the situation of double criminality. Under the principle of specificity, the demanding state can prosecute the extraditee only for the offense for which the extradition was granted and may not extradite the detainee to a third country for offenses committed before the initial extradition. ये प्रिंसिपल ऑफ स्पेसिफिसिटी कहलाता है। व्हाट इज द प्रिंसिपल ऑफ स्पेसिफिसिटी? द प्रिंसिपल ऑफ स्पेसिफिसिटी इज कि जो डिमांडिंग स्टेट है कैन prosecute the extraditee only for the offense for which the extradition was granted and may not extradite the detainee to a third country for offenses committed before the initial extradition. Okay. Although states have recognized certain exceptions to this principle and some rules allow the extraditee to waive it, it is critical to the exercise of the right of asylum. If the demanding state were permitted to try an extraditee for any offense that suited its purposes, example for a political offense, the right of asylum would suffer under both national and international law. One of the most controversial issues relating to extradition is the exception for most political offenses, a standard clause in most extradition laws and treaties that provides the requested state with the right to refuse extradition for political crimes. If anybody has committed a political crime, for example, violating the code of conduct, the electoral code of conduct, okay, things like impersonation, things like misusing the voter ID, these are all political crimes. Okay, these are all political crimes. There are many other political crimes also. Okay, so usually the countries do not enter the extradition treaty on extraditing people for political crimes. Okay, that provides the requested state with the right to refuse extradition for political crimes. Although this exception arguably has acquired the status of a general principle of law, its practical application is far from settled. The evolution of international law and the development of a nearly universal consensus condemning certain forms of criminal conduct have restricted the principle's scope so that it now excludes the most heinous of international crimes. Example, genocide, war crimes, and crimes against humanity. Okay. Apart from these and a few other cases, however, there is very little agreement on what constitutes a political crime, and states can thus exercise considerable discretion in applying the political offense exception. Now, important subcaption, the Espionage Act of 1970. The Espionage Act of 1917, passed by Congress 2 months after the United States declared war against Germany in World War One. Okay, in First World War, the United States declared war against Germany in First World War, and just 2 months after the declaration of such war, of this war, the Espionage Act of 1917 was passed by the Congress in the United States, and it made it a federal crime for any person to interfere with or attempt to undermine the US armed forces during a war, or to in any way assist the war efforts of the nation's enemies. Okay, it made it a federal crime for any person to interfere with or attempt to undermine the US armed forces. If you are intending to write, and if you are writing something against the United States Army, or you are interfering with its working or operations as a journalist, or doing anything which is detrimental to their operations, okay, or in any way if you are assisting the war efforts of the nation's enemies, this is going to be punishable under the Espionage Act. Under the terms of the act, signed into law on June 15, 1917, by President Woodrow Wilson, persons convicted of such acts could be subject to fines of $10,000 and 20 years in prison. I hope these lines are clear to you. Under the terms of the Act, the Espionage Act of 1917, which signed into law on June 15, 1917 by President Woodrow Wilson, जो भी व्यक्ति कन्विक्ट किए गए हैं सच एक्ट्स में, उनके ऊपर $10,000 का फाइन और 20 साल कैद. Under one still applicable provision of the Act, anyone found guilty of giving information to the enemy during wartime may be sentenced to death. और यदि किसी व्यक्ति ने कोई भी इंफॉर्मेशन एनिमी को दी तो उसके लिए सीधा सीधा डेथ है. ये वाला जो प्रोविजन है एस्पाइनेज एक्ट ऑफ 1917 का, ये आज भी एप्लीकेबल है यूनाइटेड स्टेट्स में. The law also authorizes the removal of material considered treasonable or seditious from the US mail. अगर कोई भी मटेरियल किसी मेल में, किसी इंटरनेट के ऊपर ट्रीजनेबल या सेडिशियस पाया जाता है तो उसको भी रिमूव कर देने की पूरी पावर, अथॉरिटी यूएस गवर्नमेंट को होगी. ओके, नाउ की टेकअवेज. The striking features of the Espionage Act of 1917. The Espionage Act is the same act under which Julian Assange is going to face the trial. Okay. The Espionage Act of 1917 makes it a crime to interfere with or attempt to undermine or interfere with the efforts of the US armed forces during a war, or to in any way assist the war efforts of the nation's enemies. Second, the Espionage Act of 1917 was passed by Congress on June 15, 1917, 2 months after the United States entered First World War. While the Espionage Act of 1917 limited Americans' First Amendment rights, it was ruled constitutional by the Supreme Court in 1919 case of Schenck versus United States. Actually, the Espionage Act of 1917's constitutionality was challenged before the Supreme Court of the United States, and while uh, the Supreme Court in 1919, while limiting Americans' First Amendment rights like the freedom of the press, it ruled that Espionage Act of 1917 is constitutional, and this was the famous case of Schenck versus United States. Potential punishments for violations of the Espionage Act of 1917 range from fines of $10,000 and 20 years in prisons to death penalty. हर रेंज की पनिशमेंट आपको इसमें मिलेगी. नाउ ये लेक्चर का आखिरी पड़ाव, फेमस प्रोसिक्यूशंस अंडर द एस्पाइनेज एंड सेडिशन एक्ट्स. अब हम यहाँ पे सारे प्रोसिक्यूशंस डिस्कस नहीं करेंगे. We'll just have a bare perusal of all these prosecutions, and we are going to discuss just two of them, Chelsea Manning and Edward Snowden. Since World War I, several Americans have been convicted or indicted for violations of the Espionage and the Sedition Acts. A few of the more notable cases include Eugene versus Debs. I don't know how to pronounce this. Sometimes the spellings of these names are different while their pronunciations are different. If you know its pronunciations and I am pronouncing it more, please forgive me. In 1918, prominent labor leader and five-time Socialist Party of America presidential candidate Eugene V Debs, who had long criticized America's involvement in the war, gave a speech in Ohio urging young men to resist registering for the military draft. As a result of the speech, Debs was arrested and charged with 10 counts of sedition. On September 12, he was found guilty on all counts and sentenced to 10 years in prison and denied the right to vote for the rest of his life. Okay. Then another is Julius and Ethel Rosenberg. In August 1950, American citizens Julius and Ethel Rosenberg were indicted on charges of spying for the Soviet Union at a time when the United States was the only country in the world known to have nuclear weapons. The Rosenbergs were accused of giving the USSR top secret nuclear weapon designs along with information about radar, sonar, and jet engines. After a long and controversial trial, the Rosenbergs were convicted of espionage and sentenced to death under Section 2 of the Espionage Act of 1917. The sentence was carried out at sundown on June 19, 1953. 19 जून 1953 को रोजनबर्ग्स जो थे ये एग्जीक्यूट कर दिए गए. Then another case is Daniel Ellsberg. In June 1971, Daniel Ellsberg, former US military analyst working for the RAND Corporation think tank, created a political firestorm when he gave the New York Times and other newspapers the Pentagon Papers, a top secret Pentagon report on President Richard Nixon's and his administration's decision making process in conducting and continuing America's participation in the Vietnam War. This was recently in the international news. This Daniel Ellsberg case was recently in the international news that he was a military analyst working in the RAND Corporation, a think tank, and he created a political firestorm when he gave the New York Times and other newspapers the Pentagon Papers, a top secret Pentagon report on President Richard Nixon's and his administration's decision-making process in conducting and continuing America's participation in Vietnam War. On January 3rd, 1973, Ellsberg was charged with violations of the Espionage Act of 1917 as well as theft and conspiracy. In all, the charges against him carried a total of maximum prison sentence of 115 years. However, on May 11, 1973, Judge William Matthew Byrne Jr. dismissed all charges against Ellsberg after finding that the government had illegally collected and handled evidence against him. ओके, सो डैनियल एल्सबर्ग लकी थे, वो बच गए. ठीक है, क्योंकि एविडेंस का कलेक्शन इलीगली हुआ था. चेल्सिया माइनिंग in July 2013, very recent, former US Army Private First Class Chelsea Manning was convicted by a military court martial for violations of the Espionage Act relating to a disclosure of nearly 7,50,000 classified or sensitive military documents on the wars in Iraq and Afghanistan to the whistleblower website Wikileaks. The documents contained information on more than 700 prisoners detained at Guantanamo Bay, a US airstrike in Afghanistan that killed civilians, over 250,000 sensitive US diplomatic cables, and other army reports. See, Chelsea Manning. This is related to our studies, today's topic, Julian Assange topic. इन्होंने एक्चुअली 7,50,000 क्लासिफाइड और सेंसिटिव मिलिट्री डॉक्यूमेंट्स जो इराक और अफगानिस्तान वॉर के ऊपर थे, वो विसल ब्लोअर वेबसाइट विकीलीक्स को प्रोवाइड किए थे. द डॉक्यूमेंट्स कंटेन्ड इंफॉर्मेशन ऑन मोर देन 700 प्रिजनर्स. 700 प्रिजनर्स के ऊपर ये इंफॉर्मेशन थी at Guantanamo Bay, a US airstrike in Afghanistan that killed civilians, over 250,000 sensitive US diplomatic cables, and other army reports. Okay. Originally facing 22 charges, including aiding the enemy, which could have brought the death penalty, Manning pleaded guilty to 10 of the charges in her court martial trials in June 2013. Manning was convicted on 21 of the charges but was acquitted of aiding the enemy. Manning was sentenced to serve 35 years at the maximum security disciplinary barracks at Fort Leavenworth, Kansas. However, on January 17, 2017, President Barack Obama commuted her sentence to the nearly 7 years she had already been held. Okay. And the very last is Edward Snowden. In June 2013, Edward Snowden was charged under the Espionage Act of 1917 with unauthorized communication of national defense information and willful communication of classified intelligence with an unauthorized person. Snowden, a former CIA, Central Investigating Agency employee, and US government contractor, leaked thousands of classified National Security Agency documents dealing with several US global surveillance programs to journalists. Snowden's actions came to light after details from the documents appeared in The Guardian, The Washington Post, Der Spiegel, and the New York Times. 2 days after his indictment, Snowden fled to Russia, where he was eventually granted asylum for 1 year after being held at Moscow's uh, Sheremetyevo airport for over a month by Russian authorities. The Russian government has since granted Snowden asylum until 2020. Now, president of the Freedom of the Press Foundation, Snowden continues to live in Moscow while seeking asylum in another country. Snowden and his disclosures have fueled wide debate over mass government surveillance of the people and the balance between the interest of national security and personal privacy. So Edward Snowden's case is very famous case of 2020, that he is living in Moscow, is still living in Moscow as while seeking an asylum, because he again leaked certain very important, he stole those documents of the National Security Agency documents, which were dealing with US global surveillance, because United States is keeping the whole world under surveillance. So all those documents related to those surveillance programs were stolen by him, and they were given to journalists. And journalists of कौन से newspapers, इतने important newspapers, The Guardian, The Washington Post, The New York Times, Der Spiegel. So ये सारे newspapers को और different journalists को ये दिए गए थे, और इसके बाद इन्होंने चार्जेस फेस किए. लेकिन इंडाइटमेंट के 2 दिन बाद ही ये रशिया चले गए और वहां पर असाइलम ले लिया. ओके, सो दिस इज टुडेज टॉपिक. इफ यू हैव एनी क्वेश्चन, प्लीज यू आर मोस्ट वेलकम टू आस्क. So I guess there are no questions today. Everything is clear to you, and you all seem to be very intelligent. Okay, so I am ending the live stream now, and see you tomorrow with a new topic. Okay, stay good, stay fine, stay healthy, and stay safe at your home. Bye bye, see you tomorrow.